I cannot begin to lay more emphasis. I cannot overemphasize how important are and relevant are the sections that I am discussing with you today. Section 5 is revocation of proposals and acceptance. As the text says, proposal may be revoked at any time before the communication of its acceptance is complete as against the proposer, but not afterwards. Now, let's look at this. A proposer can revoke his proposal in such a manner that the revocation reaches the offeree before he accepts. That is, before the offeree accepts the proposal, it must reach him if you intend to revoke your proposal. Also, it may be also that you can revoke before the offeree posts his acceptance, as the case may be. A proposal once accepted cannot be revoked, and it becomes a contract as it becomes irrevocable. A proposer has the right to revoke the offer any time. But even if, any time before its acceptance by the offeree, but even if he has said that he is going to keep it open, say till the end of December 2020, but he has a right to withdraw it if he likes tomorrow. The only condition being, which I am laying very important, is that the acceptance must not be communicated to him by the offeree. So let's understand, the proposal once made can be withdrawn at any time before the offeree accepts it or conveys his acceptance or even posts his acceptance. The second part of section 5 says an acceptance may be revoked any time before the communication of acceptance is complete as against the acceptor, but not afterwards. So the language of the section is clear enough to say that the revocation has to be done before its acceptance by the offeree. Unless the promise is supported by the consideration, the condition being that the that the bidder of an auction at an auction shall not be entitled to retract the bid unless it is inoperative in law. Let me explain it to you that in the case of, there is a case here of Linga Gowder versus State of Madras, where it has been said that a condition that the bidder at an auction shall not be entitled to retract the bid is inoperative in law and cannot take away the legal right. This is the judgment of Linga Gowder versus State of Madras, AIR 1971, Madras 28. However, earnest money may be forfeited at a bid or a bank guarantee invoked in case of withdrawal. The judgment of National Highways Authority versus Ganga Enterprises is by Supreme Court, AIR 2003. The judgment said that where a bid is lodged and thereafter the bidder does not fulfill the promise or the offer, then it can be that you can invoke the guarantee or you can forfeit the deposit. Also, let me take you a step further. An application by an employee seeking voluntary retirement cannot be withdrawn if accepted. Now, what is that application? Application is a proposal. If the employer has accepted, then it is too late for the employee to seek withdrawal of it. Also, there cannot be a revocation in case the tender is accepted. Let me say what are the conditions attached to that. Where the bid has been conditionally accepted, subject to confirmation by the higher authorities. There, the contract is concluded only after the condition is fulfilled. Because they may say, you will see many times, you will see they say that you are the lowest bidder and your bid will be accepted, of course, subject to the approval by the board or subject to the approval by the chief minister or whatever their conditions are. Now, obviously, the entire contract or acceptance is subject to the fact that it has to be accepted on record either by the board passing the resolution or it is by the chief minister or by the chief secretary, whatever the condition is. Till then what is the status? Till then, you have a right to withdraw. And then your bid can be withdrawn even if you have lodged a bid and you have not been communicated that the higher authority has accepted it, you have a right to withdraw it. Now, let me also say, bidder, what I am trying to lay before you is that the bidder will be bound only after the confirmation of acceptance by the higher authority is given. I have also briefly dealt with the issue of voluntary retirement. Let me deal with the issue of resignation. Resignation is like a proposal to bring the contract of service to an end and is governed by sections 4 and 5. It is complete when it is put in the course of communication. That is if it is out of the reach of the proposer and as against the person to whom it is addressed when it comes to the knowledge of the person to whom it is addressed. A resignation, however, a resignation of an office bearer of a society or a club can be withdrawn before it becomes or before it is effective. Let me quote a judgment to you of Supreme Court, which is a judgment of 1978. It is a judgment of Union of India versus Gopal Chandra. Friends, there is a difference. Resignation of an employee becomes complete. It is a proposal where the proposer is bringing the employment contract to an end and it is complete, it cannot be withdrawn. However, resignation of an office bearer can be withdrawn and before it becomes effective. That is, let's say I am a secretary of a society, I have resigned, the society has not accepted it in its meeting, the meeting of the office bearers. I can at any time withdraw it and I have a right to withdraw this. Now, let me take you further to section 6, which is the procedure laid out how the revocation can be made. It says a proposal is revoked, 1, by the communication of notice of revocation, by proposer to the other party. So what happens is the proposer says, I revoke my proposal. And he says it to the person to whom he has already made an offer. Secondly, it can also be revoked by lapse of time prescribed in such proposal, where you often see that a letter of appointment may be sent where they say, if you accept this, you have to communicate within 15 days. Otherwise, it will be treated as automatically withdrawn. Also, on if there is a commercial deal, then if somebody says this price is only open up to a certain date, then and whether if you accept, please convey in writing. Otherwise, and if no time is so prescribed by lapse of reasonable time. What's that reasonable time? It's a matter of fact. Without communication of acceptance. What is that reasonable time? You cannot sit on a offer made to you forever. You have to, at some point of time, say it could be 30 days, it could be 15 days, it could be reasonably 3, 4 weeks, 2 weeks, whatever is the reasonable time, as we as a common man will understand. It could, if not communicated, then it will, of the proposal so made, it could be, it could lapse by itself. Third, by failure of the acceptor to fulfill a condition precedent to acceptance. The language is very clear, where a proposal is made and it is said that if you accept, please convey your acceptance in writing. Then the condition precedent is that you have to convey your communication acceptance in writing. And if it says send it on a letterhead, then you have to send it on a letterhead. If it says, please, if you accept the proposal, then you please send 100 rupees, then you have to send 100 rupees. Fourth is natural, where there is a death or insanity of the proposer. I mean, somebody makes a proposal to you and he dies, then obviously there is no proposal. Or he becomes insane if the fact of his death or insanity comes to the knowledge of acceptor before acceptance. Now, this is something which I will take you further when I discuss section 11 with you, as to what may happen if a person at the time when he entered into discussion with you or when he made an offer to you was normal, but by the time you accepted it, he becomes insane, then, and he pleads his insanity, then it is not possible for him to retract what he has offered, because pleading insanity at the time when the contract is concluded doesn't give him any defense. But we'll discuss it as we come to section 11. Let's see here what section 3 says. It says, revocation may be communicated by an act or omission. Revocation, how made? Section 6 takes us back to section 3. The spirit of this is how revocation made. Revocation can be made, communicated by an act or an omission by the proposer who intends to communicate the offer. Now, section 5 deals with the revocation and time before which it can be effectively exercised. This section provides the mode in which a proposal can be revoked or shall stand revoked. Now, clause 1, by the communication of notice. The notice of revocation by the offerer or the agent has to be expressed or implied. It can be uh, by by varying the terms. Today I say I will be paying you 10,000 rupees if you do this for me, and then I say no, but uh, I'm revising it to 5,000. That means I have varied the terms, and that means the previous one. By varying the term, I have effectively or by conduct revoked my previous proposal. Now, the express language of the section, and let me say here is you have to clearly understand the express language of the section precludes a revocation other than the one communicated by the proposer himself. And the Law Commission has thought fit not to make any change. Please understand that the express language of the section precludes a revocation other than the one communicated by the proposer himself. Now, what is that 2? Subclass 2 says the power to accept the offer ends at the time specified in the offer. If the offerer stipulates a period of time, say 15 days, time would run from the date of receipt of the offer by the person to whom it is offered. Supreme Court of Canada has clearly held that this is the time calculation will be from the date when it is received by the offeree, and the time ran from the receipt of the offer at the offerer's address, at the offeree's address. And now let's say what happens when the offer is received at your proper address. Let's say you have gone on a holiday and it is delivered at your house, but you were not there. Now, the time would lapse even if, the only condition being that it has been received at the right address and at the right spot where it was addressed to. If it has been delivered, then it won't matter that you were not there or that you did not see it or whatever. The proposer will lapse even if the acceptor is prevented from accepting within the stipulated time. You were sick, you were being operated, you were in a hospital, whatever, but what the circumstances beyond your control, however, the time would lapse and the proposal would lapse. Friends, the condition precedent for acceptance was brought out in a case called Pipriya Sugar Mills Limited versus Pipriya Sugar Mills Mazdoor Union, AIR 1957, Supreme Court 95. Here it was held that the condition is to be complied with by the acceptor before acceptance. That is, offer made to trade union to withdraw the strike. If they did so, workers would be paid some amount out of the profits. The mill was being sold. They were told, if you withdraw the strike, then you would be paid some workers, your members would be paid some profits. Union did not respond, held there was no contract. And we would continue with only one more aspect under this section, that is death of the proposer. There shall be no proposer if the acceptor has notice of death or insanity, that means a proposal has been received, but you also learn that the proposer has died or has become insane, then obviously you cannot accept this. For example, LIC policy, after it has lapsed, cannot be revived. We shall continue this in the next discussion. Thank you very much.